The next point is covenant running on land. Now, what do you mean by a covenant? Covenant means a term or stipulation. It may also imply a duty, obligation, or liability. What happens is many a times in case of land deals, the seller tends to put a condition, tends to put a stipulation or a term in the contract saying that this land should not be used for construction purposes. This land should only be used for agricultural purposes. You should only do agriculture on this. If a contract is entered wherein a seller is putting such a condition, and if the buyer is agreeing, then the buyer has the duty to abide by it. He cannot start construction on that land. He only has the right to do agriculture. Tomorrow, if the buyer does some construction on it, the seller will have the right to sue the buyer and get the construction demolished. There can also be a case wherein the seller wants only agriculture to be done on the land, and not only agriculture, he may impose a condition wherein the buyer can only produce potatoes on the land because he thinks this land is best suited to potatoes, and if any other thing is produced on it, it may reduce the fertility. So he puts a condition because he has emotions with the land. He puts the condition that only potatoes should be produced on the land. So if the buyer agrees, he has to abide by the condition. Now it becomes his duty or obligation to produce only potatoes on that land. There can also be a case wherein the seller has some liability, some land arrears, some land revenue arrears or some taxes which he needs to pay to the government. So the seller may put a condition over the buyer that before taking the charge of the land, you have to clear my liability that I have in the form of taxes to the government. So now this becomes a covenant, this becomes a condition, this becomes a stipulation from the side of the seller, and this becomes the duty or the obligation on the part of buyer. And if the buyer agrees, he'll have to first clear all the dues, all the taxes which the seller had to pay, and then he can use the land for whatever purposes he wants. So in such cases, what happens is even if the seller dies, the legal heir or the legal representative of the seller can sue the buyer, though the legal heir or the legal representative was never a party to the contract. Parties to the contract were seller and buyer, and possibly the legal representative or the legal heir of the seller does not have any business in this contract, but the court gives him this right. The court imposes a duty on the buyer to follow the condition, and if the condition is not followed and the seller has died, the legal heir of the seller can enforce this duty. He gets the right to enforce this duty even though the legal heir is not a party to the contractor. He is a stranger to the contract, yet he gets this right. He can sue him. So this becomes a exception to the doctrine of privity of contracts. There was also a landmark case in England, in London, wherein this point was raised. This point was the main contention of the case, where there was a person, let's say X, he owned a house, and before the house there was this garden. This house belonged to X and he entered in a contract to sell this house to Y for some pounds. But since X was very much attached to this property and the garden, he put a condition in the agreement in the contract with Y that the garden before this house should never be developed. That is, developed in terms of construction. There should be no construction which should come over this garden. This condition was agreed by Y and the contract happened. Some years down the line, let's say 8 years later, Y sold this property along with the garden to Z, who was a reputed builder. He wanted to construct a building over this property, including the garden area. So the whole land, the house and the garden area would be now developed, and it would be developed into a building. When X came to know about this deal between Y and Z, he went to Z. X ran to Z. He said, I have sold this property to Y. And there was a condition in the agreement, in the contract that we entered into, that this garden will never come under construction. This area will remain as garden area only. So you cannot construct a building over this garden area. So on this, Z said, look, I have entered into a contract with Y. Y is now the owner of this property. He is the person who's supposed to put conditions on me. If he is ready, if he is okay, and I am okay, you are nobody to interfere in this contract. This contract is between me and Y, that is between Y and Z. On this, X said, I had originally put this condition when I sold the property. So this condition will be maintained, will or has to be followed, whoever is the owner or the next owner of the property. Whoever is the prospective or the next owner or the coming owner of the property will have to abide by this condition. Now both have their contentions. Z says X is a outside party to the contract between Y and Z. Y is the real owner of the property. Z on this contention does not allow X to put his case before him. X says, since he was the first owner of the property and he has put a condition when he was selling this property that garden area should never come under construction, it has to follow. So X here is correct. The condition should be followed by any of the future owners. But can X enforce this condition on Z? X can enforce this condition as long as Y is the owner. But can X enforce this condition on Z? Yes, X can also enforce this condition on Z. Even though X is the outside party, X is not a party to the contract between Y and Z, he is an outside party. Yet he can impose the condition on Z. This is because this point that any covenants, any conditions, any terms or stipulations which are running with a land have to be followed. And if they are not followed, any of the previous owners can impose them or enforce them on the future owners. So, this point is an exception to the doctrine of privity of contract.